Hello and welcome to our webcast on the General Data Protection Regulation, or GDPR. My name is Rav Hare and I'm a partner in PwC's Financial Services Risk and Regulation Practice, where I specialise in data regulation. We scheduled this live webcast to discuss if banks, insurers and asset and wealth managers are taking the GDPR seriously, what they should be doing in 2017 to prepare for the regulation and what the challenges will be. We'll also discuss how to take a risk-based approach to the GDPR. Not all organisations will be compliant in 2018, but what is a regulator likely to focus on and how you can mitigate the risk of fines? Most importantly, we wanted to share insights with you and to answer your questions. I'm therefore delighted to be joined by James Drury-Smith from our legal practice, Taiba Arif and Craig Skinner from our Financial Services Risk and Regulation Practice. This is a live webcast, so please do send us your questions using the box on your screen, or tweet using the hashtag regulation Q&A, and we'll do our best to cover them during the session. So to kick off the debate, James, can you please tell us about the GDPR and why it is needed?
Yeah, sure, Rav. So GDPR, the General Data Protection Regulation, it's the biggest change in data protection laws in 20 years. And that's not just in Europe, that's worldwide. And the reason that we're looking at this now is that the laws we operate under today are now well over 20 years old. So we've got the Data Protection Directive 1995, which then led to the Data Protection Act 1998 in the UK. So those laws are quite old now, and they were drafted and brought into force at a time when we didn't have things like cloud computing, concepts like big data, social media, mobile computing and profiling. So the world's changed a lot since that legislation was brought into force, and the Parliament, the European Commission and also the regulators have taken a look at this and said, well, look, you know, things have got to change because the law isn't fit for purpose any longer. So some of the big changes that we're seeing come into force now are the big headline that we all talk about, which is the 4% fines for companies of their global annual turnover. That's the big stick that the regulators are hoping that they may be able to hit an organisation with and encourage compliance. But outside of that, there's a lot of other changes as well. So we've got the idea that you now need to be able to clearly evidence your compliance with the General Data Protection Regulation. That's called the accountability principle, and it brings in concepts such as privacy impact assessment. So, you know, when you develop a new processing operation or you bring a new IT system online, you need to be able to document from beginning to end to show how you've assessed it to ensure that it complies with the GDPR. We've also got ideas such as privacy by design as well, which is that you'll develop principles that you build your new IT systems against that ensure that those systems are built in compliance with GDPR. Right. In addition to that, we've got new rights for individuals that they can enforce against organisations. So a lot of people will have heard about the right to be forgotten, the idea that someone can come to you and say, please delete the data that you hold about me, or the concept of data portability, that an individual can come and say to you, please move my data that you hold about me from you, Mr. Service Provider, to the next service provider along. So some big changes there. And one of the other big pieces that we're seeing is breach notification. So organisations, if they get things wrong and lose somebody's personal data, will now need to notify a regulator within 72 hours and then notify individuals without undue delay. So some really big changes that are coming along, Raf.
Yeah, so given all of this change, and probably one of the biggest changes in this area for a long time, what is the regulator actually doing about it?
Well, it's interesting. So, you know, I think there's been some criticism up to date that there hasn't been enough guidance coming out from the regulators, but we're definitely starting to see that. So the ICO, the Information Commissioner's Office, the UK regulator, has had guidance for quite a long time now on general interpretation of the GDPR, and that's available on its website. But we just saw last week that the Information Commissioner's Office issued in draft guidance on more granular topics. The draft that came out was around consent and what consent means under GDPR and the mechanisms you should be implementing to make sure you have valid consent as well. We're then also seeing outside of the ICO that the Article 29 Working Party, which is the working, the representative group of all the data protection authorities in the European Union has also started to issue guidance. So we've had guidance on data portability, and we've had guidance on data protection officers come out from the Working Party. And both the ICO and the Article 29 Working Party have got a schedule of guidance that they intend to bring out over the next year.
I think it's probably worth noting, though, that the guidance isn't the silver bullet that is going to solve everybody's challenges or answer everybody's questions. For example, that guidance is cross-industry, so there is a need to interpret that into financial services. I suppose I would just add as well that the Information Commissioner obviously is taking this very seriously, and although we've heard mention of this is not a cliff edge, so day one won't result in multiple fines as soon as this goes live. The Commission has made it very clear that they expect to see consideration from organisations around how they'll become compliant with GDPR, and also we expect to see evidence of that, so programmes in flight that address the need for compliance and start to address some of the mechanisms that they need to put in place to protect subjects' data.
Yep. And of course, the ICO will need to increase their capacity and capability to handle the investigations and the complaints that we're all expecting to come into them based on the new rights that GDPR is giving to the citizens.
And of course, we've also heard that the ICO has increased its headcount to manage all of this. So, they are expecting a lot to come through. So this, of course, is a real challenge. So what about Brexit? I mean, we're not far off. The UK is taking a big decision to go forward with Brexit. So what's likely to happen post-Brexit, and what do we need to consider in the run-up to it? James?
Well, in the short term, the answer is carry on getting ready for GDPR to come into force. And if you just want to look at this through a time frame lens, GDPR will come into force May 2018. It will be part of UK law, and the UK at that point will not have left the European Union. So the General Data Protection Regulation will be part of UK law. I think what is most interesting, though, is what happens in the longer term. Do we stay compliant as a country with GDPR requirements? And there's two views you can take on this. There's one view where we actually start to get rid of some of the more onerous elements of the General Data Protection Regulation, and we try to become more business and commercially friendly to organisations that are out there. The other view is that actually, well, no, we carry on with GDPR. We might even go above the requirements of GDPR. And the argument for doing that is so that we can continue to share information between Europe and the UK after we've left the European Union. We'll need to do that potentially if we want to be considered adequate, so we can receive that data. So it's going to be quite interesting in the longer term where we end up.
No, most definitely.
Yep. And I would just add to that, though, but in the shorter term, there isn't really any change. So our clients need to set up their GDPR programs to adhere to the GDPR as is and to focus on continuing with their business. And quite a lot of our multilaterals, they operate in the jurisdictions where GDPR applies. So from my perspective, there isn't really much change in the immediate sort of 2 years, I think. Yep.
But I guess, there is still a lot happening and a lot is still evolving as we move forward. And I think if we look longer term, we have and are actively involved in a number of conversations shaping what may happen post-Brexit. Certainly last week, Stuart Room, our data privacy partner, attended Parliament where he gave evidence at the House of Lords Select Committee. So certainly, it is still evolving. There's still a lot of decisions to be made around how the UK will enact the GDPR going forward post-Brexit. So a lot still to come. So thank you very much, James, Taiba, Craig, for that debate around GDPR and Brexit. So let's look at our financial services point of view. What is our point of view? So Taiba, Craig, can you share with us your point of view in terms of what is happening within the financial services sector?
Let me start. So I think a lot is happening in the regulatory space for our clients across insurance and banking. They're currently running large transformation programs, be it for MiFID, for Solvency II, or the new accounting standard IFRS 9. So there are competing priorities. However, as James said, there's a 4% global annual turnover, which for any FTSE company it might be 100 million plus. This really does warrant everybody's full attention. Now, having said that, there is a lot to do. There isn't that much time left between now and May 2018. And our point of view is that there's always been a lot to do, actually, because most companies aren't just making up for the gap, the 2-year period of adoption, but actually the gap is larger, as James said, in terms of the 95 directive and the new requirements that the GDPR represents. So it's really important to prioritise, but the key question then is, how do you actually prioritise?
And to put that time frame into context, as of today, there are only 308 working days left until the GDPR comes into force. So that's kind of forcing organisations to look at how do we prioritise and what goes into that programme for the next 308 days, and maybe what's slightly longer term. So a risk-based approach is really important, but a risk-based approach and a prioritised approach is really based on organisation understanding where they're at with the GDPR, and the nature of their organisations, the nature of their third parties, the nature of data transfers, the nature of key processing and key data and where it is. So there's a real focus on not just trying to boil the ocean here and do everything at a flat level, but actually looking at where should the emphasis be put over that very short time frame.
Yeah, but certainly there's also an opportunity here as well.
Yeah.
Taiba, maybe you want.
Yeah, so I would like to add that actually we talk about the carrot a lot because of the fine and it's such a big number, but there is an opportunity here to build better relationships with the customers by being really open and transparent about what data you have about them, why you're collecting it, how you intend to use it, and ultimately I think that will build a stronger relationship between the bank and its customer and lead to growth.
And certainly, given that there's an opportunity on one side, there's also a risk on the other side with potential litigation. And how may that affect organisations, James?
Well, right, actually, we think that could be one of the biggest issues coming out of GDPR when you look at the longer term. So people talk about the fines and get quite focused on that. But when you think about it, there are only 28 regulators, soon to be 27 in the European Union, and they need to sort of find out you've been doing something wrong and then bring an action against you. Whereas there's 500 million or so citizens in the European Union and more globally, each of which, if you misuse their personal data, may be able to bring a claim for damages against you. And we definitely feel that in the longer term, what will probably start to drive compliance, if not more so, but at least equally to the fines, is the threat of litigation.
Okay, great, thank you. I mean, it is clear that the GDPR will bring more rigour, business benefits, and in some cases a lot more uncertainty as well. So we do need to stay close to this, certainly over the next 12 months, and see how things progress. So thank you very much for that debate. In terms of the financial services challenges, over the last 18 months, we have seen a lot of activity in the market. However, financial service organisations have been particularly slow in terms of taking off with the GDPR or taking it seriously. So, Craig, can you share with us some of your insights and the challenges you've seen from an insurance and asset and wealth management perspective, please?
If I take a step back overall across FS, I think we've seen 3 key phases here. The first being an initial gap analysis. So that's a look at what is the organisation doing around the current privacy regulation and how does that compare with what's written in the GDPR. So that initial gap analysis tends to be a desktop exercise, often conducted by legal. And that really feeds the next phase, which is then looking at how do we shape and formulate a programme of compliance to run maybe over the next 1, 2, 3 years to become compliant with GDPR. So taking those gaps identified in phase 1 and really playing them into a programme plan.
Yeah.
Then the third stage is where, once the programme has been completed, what does the business as usual structure, architecture, operations look like for an organisation? So, for example, what is the privacy office doing on a day-to-day basis? What are their interactions with the business post that programme? speaking specifically about insurers, part of the challenge with insurers has been a historic underinvestment in systems, in legacy systems, which has resulted in organisations, insurers, not really understanding what data they have, how often they keep it for, what they use it for, how it flows between systems. So I think for insurers that's driven quite an early indicator that there's quite a lot to do, which has started the insurance industry off maybe a little bit earlier than banks. Conversely, with asset managers, typically somewhat behind or somewhat slower on the regulatory side, and very much a view that, you know, where we've got third-party administrators, you know, they handle our data, and therefore they need to be compliant. Our point of view is actually, you know, whether a processor or a controller, the asset manager is as liable in most cases as the third party. So actually there is as much of a need to become compliant with the GDPR as just pointing the finger at the third party.
Sure, great. I mean, certainly, you know, you mentioned that insurers have sort of taken sort of a lead compared to asset and wealth managers. How does that compare with the banking industry, Taiba?
So I think I'd echo quite a few of the things that Craig has just said in terms of areas of focus. And let me start by looking at third parties. I think there's a lot of focus around the data supply chain for banks as well, to really understand what data is being exchanged and actually to formalise those agreements. Quite a lot of them are still, I guess, gentlemen's agreements in terms of where data is concerned. But what we're also seeing is large organisations applying a similar approach to their internal organisational structures, to putting in place data transfer agreements and formalising that relationship between functions and lines of business. But I would sort of want to come back to the point that actually, I think to a little bit to our surprise, the banking sector has been slow in mobilising properly for GDPR. Now we've seen pockets of activity in terms of more of a federated approach, HR department looking at GDPR on their own, looking at what that means for HR data, but really only in the recent few weeks and maybe months, banks are coming together in terms of putting in place an overarching program and finding the right sponsor. And I think sponsorship and finding the right sponsor has been a bit of a debate as well, because we see that some banks have made the legal counsel the main sponsor for a GDPR program. In other banks, we're seeing the chief information officer take the lead, and yet in other places, it falls to the chief data office to look at it. And banks are still struggling to find the right focus for their program. So the balance between looking at consent and all of those things, the data management side of it, because that's pretty big, and also balance out the security, the cyber as well as physical security. And I think one last thing to add to that is, I think cross-industry actually, the resourcing gap. So in the marketplace, there aren't enough people who have the right skills and experience in terms of data protection to help deliver on those programs. And I think we're seeing that across the board.
So what about from a legal perspective? I mean, you know, we're seeing a lot of challenges across the industry from a financial services perspective, but clearly, you know, legal plays a big role in this as well. So what are the challenges that we're seeing, James?
Yeah, that's right, Rav. You know, there are a lot of challenges for the legal teams as they become involved in this. And I'll start by echoing what Taiba has just said in terms of resources. I think that is one of the biggest challenges at the moment. There are not enough people with the skill base that's required to implement GDPR. So there are a lot of job adverts out there at the moment looking for people with background either as data protection officers or maybe a legal background with data protection, seeking to find people. And I think the demand is going to increase over the next few months, and that's going to make it difficult for organisations to find the right resources. So I think what we're seeing and what we anticipate that we will see is that more focus will go on in-house training, looking at the individuals that you have already, and this is the same for the legal teams as it is for every other area that becomes involved. They will need to look at training people and sort of boxing clever around GDPR in order to be able to get to the right position in terms of the skills they need. I think in terms of some of the other challenges that legal are grappling with, one of them is, what is legal's role? I think traditionally, legal has had a very big hand in all elements of data protection. But it's very clear GDPR requires a multidisciplinary approach. So it's not just the lawyers. You need compliance folk, you need data protection officers, you need IT security, you need risk management, you need your data analytics teams. You need everybody that touches data involved in some form or another. And I think legal working out its role in that is an important step and a challenge for a lot of the legal clients that we work for.
Yeah.
Now, if we look at specifics under the GDPR, then there are some focus areas that we are seeing legal grappling with. One of the key ones is looking at the type of data that an organisation holds and seeing if they can justify the processing of data under GDPR requirements. So the GDPR requires that if you hold data, you have grounds for processing that data which are reflected in the GDPR. So one of the big things that legal teams are doing right now is looking at consent and saying, is the consent that we've collected previously good enough to carry on justifying the processing of data going forward? Or do we need to look at another ground for justifying the processing of data, such as legitimate interest? Other areas we're seeing the legal teams involved in is updating privacy notices, making sure that the right information is being provided to data subjects or individuals at the right time about the data that's being collected, what it's being used for, and who it's being shared with. Because those requirements are really increasing now. Legal's also involved in a lot of policy drafting, so policy around the new subject rights like the right to be forgotten, data portability and subject access requests. And I think the two or three other areas that I'd just very quickly flag is obviously a big role for legal in looking at third-party relationships, updating contracts with suppliers and data processors of personal data, developing standard contractual clauses that can be used going forward in those relationships. Legal's also got a role in breach management, looking at how it will seek external advice, whether it can put privilege around that sort of advice that's coming in. Also looking at how it will interact with regulators, notifying them, whether it's how it will interact with individuals as well. And the very final piece that we see legal involved in quite a lot is GDPR representing the opportunity to go back and look at international transfers. So as a general rule, we're prohibited from moving personal data outside of the European Union or the European Economic Area unless certain exceptions under data protection law apply. So we've got the legal teams now looking at how the data is being moved around its group and to third parties and looking at, is this an opportunity to put new data transfer mechanisms in place? Do we go through and update our model clauses so that transfers can take place between entities in Europe and entities outside Europe? Or do we implement things like binding corporate rules within the group to allow the safe transfer of data? So I think they're the key areas that legal's really getting involved in.
Yeah, that's great, thank you. And some really great insights there in terms of the challenges. I'd say it is quite clear that we are seeing a number of challenges across the FS sector, and our point of view is that organisations need to act now. We are 308 working days away from the GDPR going live, and ultimately we do not believe that organisations will be 100% compliant. It is essential, therefore, that a risk-based approach is adopted in working towards a GDPR to demonstrate to the regulator that you have a considered and comprehensive programme and a plan in place to address the ask. So, on that basis, I think we should open the floor up to some questions and see what the audience has to ask. So, the first question that I see is, how is the UK regulator likely to assess compliance when the GDPR comes into force? Maybe James, you could take this one.
Okay, yeah, I'll kick off. So, you know, we've already mentioned that you know, it's not going to be a cliff edge. That's the message that we're hearing from the ICO, at least at the moment, is that come May 2018, 4% fines aren't going to be levied straight away. You know, what we anticipate, though, is that, you know, the ICO has to investigate when there is an accusation that somebody is not complying with data protection laws. And it should continue along the usual path that it's taken to date, which is to look at that complaint, look at whether there's been any harm to the individual, and then assess from there whether it needs to take enforcement action, and then what sort of enforcement action that should be. So what we anticipate is that, you know, there will be a gradual move by the ICO to enforce the GDPR in its entirety, but there should be a period where organisations are able to demonstrate that they're moving in the right direction, and provided they've tackled the most harmful areas of the general data protection regulation, so this risk-based prioritised approach that we talk about, we'd be very hopeful that that would be recognised by the ICO as a sufficient way, because as we've already said, too much to do, too little time to do it.
Yeah.
And if we just look at what we've seen already from the regulator, you know, last year it issued its highest fine of £400,000 against an organisation, and that continues a theme of those fines increasing. So if we have another significant event, data loss potentially in the next the period between now and May 2018, then we should expect that fine to get higher. And then when we go past May 2018 and the ICO can issue much higher fines, so at the moment it's capped at 500,000, then I think we will see that gradual increase. As I said, you know, it's probably not going to be that sharp shock.
I think just to add to that, I mean, the GDPR, from a very practical level, GDPR, you know, talks about accountability framework, talks about privacy by design, and so I think in terms of how will the regulator assess, I think, you know, having that strategy in place, organisations having thought about that, documented that, and have that strategy ready to present in the unfortunate event of, you know, any attention from the regulator is key. And actually, it's, as I say, it's written into the GDPR that is a requirement. So jumping over that seems like a bit of an own goal if you don't have that in place.
Yeah, Craig. I think that's a really good point in the sense that, you know, what we've seen previously from the ICO is that if you are the unfortunate victim of data loss, or you negligently lose data and you notify them, they're going to ask you a series of questions. And those questions start with things such as, what was the data that you lost? You know, who's been impacted this? What's the volume of data that's been lost? But then they rapidly move on to the next part, which is to say, can you show us how you've documented your compliance? So you'll probably get asked to show your security policy that you have in place, or policies. You may also be asked to show the training that you've given staff to show that you've got appropriate controls in place. You could even be asked to show your privacy impact assessment documentation as well. So we call that typically the paper shield, you know, and the paper shield is going to remain such an important part of GDPR compliance going forward.
I think that's really key as organisations, you know, see some organisations run straight into remediation without that initial step. I think that's really key.
So I guess the key questions from me would be, will the regulator actually be enforcing this from day one, or will they continue to apply a level of leniency given the breadth and scale of what is expected of the GDPR?
You know, it's a difficult question. I think if the ICO was faced with a very major breach of GDPR, it would have to act in that situation. I'm hopeful, and judging by the way the ICO has approached regulation in the past, it's always taken an approach of wanting to educate and inform, rather than necessarily hitting people straight away with a very large fine. It's sort of, the large fines come when the breach of data protection laws is so inexcusable that they feel that they must act in that situation. And I think that's what we should anticipate continuing. If you can demonstrate that you've had a very good GDPR program in place, you've made significant movement from now, you know, and May 2018, and you've tackled some of the highest risks to individuals, then that is going to definitely mitigate any potential action against you.
Great, well, thank you for that. Let's take another question from the floor. Where does a data protection officer sit within a financial services organisation, and how does that role interact with other business areas? Maybe that can go to Taiba?
So I think typically what we're seeing is that the data protection officer sits in the compliance or / legal area, and they generally work in a sort of advisory capacity. But I think that might be shifting a little bit given the breadth and scale of GDPR. And we've seen some of our clients building out larger, I guess, offices around data protection. So not just one lead officer, but actually a larger capacity to respond to and support the wider organization.
Mm-hmm. And I'd add to that, I mean, the GDPR states a level of independence for the privacy officer, so actually sitting in compliance helps that out. But I think, you know, what we're seeing is certainly compliance are involved in the programs, but in BAU they need to sit in that more independent position.
Great, thank you. What is the territorial scope for the GDPR? James?
Okay, so territorial scope for the GDPR. I'm not going to quote the GDPR word for word. I probably couldn't do that, in fact. But you know, if we break it down into its most simple elements, the GDPR will apply to you if you are established in the European Union. So really, if you're here, you have a physical presence, you're collecting data, you will be caught by the General Data Protection Regulation. But its territorial scope is actually quite wide, and what we're seeing now is a difference between the existing regime and what we're going towards is how it's being expanded to capture organisations outside of the European Union. So the other way you can be caught is if you're outside the European Union and you target services and goods at individuals within the European Union, and through that you're collecting their personal data. In addition to that, you can also be caught if you're monitoring the behaviour of individuals in the European Union. So that's sort of, you know, websites, watching how their users use the website, the pages they visit, what they click on, that sort of thing. Those sort of ideas we've got through there. I mean, what has happened through that extended scope really is that the regulations, when you look at GDPR, actually, you know, it's a regulation, some people argue, that was definitely developed to tackle social media and large tech companies. And that territorial scope idea is really aimed at the next large social media company or the next large tech company coming out of somewhere like the US that overnight can have hundreds of thousands, if not millions of users before it's actually established itself in the European Union. And what the GDPR is very clear on is in that situation, you're caught.
Yes, of course, yeah. No, that's great. Thank you for that, James. What is the biggest risk for financial services firms in complying with the GDPR? I think we've already covered that question off. The next one we have here, what time and resources should firms set aside for the GDPR implementation? Maybe Taiba?
Well, that's a big question to answer in terms of what firms should do. But I think I would probably come back to the things that we've pointed out in terms of this really risk-based approach and looking at having a strategy for the outcome that you're looking for your GDPR program. And I think the balance is about looking at GDPR requirements from a regulatory perspective, but also from a consumer's perspective, and to mitigate the risk of potential litigation. And the other thing, coming back to the prioritization and the risk-based approach, is to really have a hard think about what are the key data areas, and even within data areas, tranches of data, key processes that capture and process personal data, and also which systems you need to be looking at fortifying to be able to set out a program and size the program. I think that's a challenge that actually quite a lot of our clients are currently trying to tackle.
Right.
And it's very particular to their organization and their risk appetite. We aren't seeing a sort of like a general approach across both insurance and financial services. It really depends on the special characteristics of the organization, the geographies where they operate, what's their previous relationship with the regulator, and also the complexities of their data supply chain in terms of the third parties and the type of personal data they're currently handling.
Yeah.
think.
So it's a complex question to answer.
And it is, and all of those things are leading to a real range on the budgets that we're seeing as well being put aside. You know, we're seeing some organisations put away just a few 100,000, thinking that might be enough to tackle it. Normally that's for the initial gap analysis phase, but then you rapidly see, particularly on the FS side of things, we see those budgets spiral, and one of the big things that feeds into that is the existing resources and capabilities they have in there. So the smaller budgets, the smaller £1 million budgets, are where we see very established privacy functions, where we see good resources already in place. But we're definitely seeing budgets that are in the, you know, 15, 20 million, aren't we, from the work that we're involved in. Yeah.
I'll just add to that. I mean, you know, GDPR is getting a lot of attention in organisations, and you know, there's a tendency to, you know, this is a dream come true for, say, IT, who this is their opportunity to get their entire roadmap squeezed into a 2-year window and get it paid for under GDPR. So we talk about, you know, risk-based approach, but there's also a smart way of assessing this to work out actually what really should be in scope for GDPR. And is this really GDPR, or is this just, you know, existing plans being, as I say, tipped in under the GDPR banner? So there's quite a lot of that happening. And so we've seen, in the worst case, we've seen a program plan with 17 work streams, for example, which clearly is a collection of various initiatives being put under that banner.
I just want to add to that a little bit, because I do think that there's an opportunity to look at other regulatory transformation programs that you're running and look at how you can, you know, leverage some of that. And for banking in particular, if I look at all the work that's gone in for BCBS 239, there's generally a good framework around data management that could be leveraged and extended onto other areas such as personal data. So I think approaching GDPR in coordination with some of the other larger transformation program might be a good way of looking at it, and hopefully helpful in terms of sizing and setting the budget for this program. But I think it's becoming clearer that there's a big number needed to actually meet all the requirements.
So certainly not to be just narrow focused and just focus on the one side, but to look more holistically and see how you can leverage other areas of transformation programs to sort of really aid and assist the direction of this. Exactly. Great, well thank you for that. How do firms prepare for the data portability requirements with so little regulatory uncertainty on the details? Craig, maybe you want to take that?
So portability is a new requirement under the GDPR, and it's related to data that subjects provide to you. So quite different to some of the other, you know, subject access requests and the right to be forgotten. We're just talking about that data that the individual has given to you. Organisations are looking at ways to you know, use technology. One of the requirements on that transfer of data is that it's made available in a machine-readable format. So that's sparking some questions over, could we build interfaces in our systems, APIs, that allow the free flow of data into that machine-readable format to be provided to the next service provider, next insurer, bank. It's quite a challenge in that, you're right, I mean, the Working Party has come up with guidance, and it has issued guidance. But again, still at an industry level, that still doesn't get down to some of the specifics. So, you know, some of the bank, you know, switching groups that have been formed are looking at that and looking to come up with an industry-based solution. But it is still a challenge. But I would say, you know, focus directly on what the requirement is, because it is slightly different. Look at the ways in which we can embrace technology. And then you know, seek industry groups who are trying to bottom out exactly what this means specifically for FS.
Are we actually expecting a standard for the portability of data? I mean, if we look in the UK specifically, we've had the current account transfer from one bank to another, where data is ported across quite seamlessly as well. So do we envisage something to come across from the ICO or some form of standard?
I think we're moving towards, we've got to get to a standard is my view here, in that if you look at what portability has been designed to do, it's to make it easier to switch providers, so you're not locked in and you've only got one choice. So ultimately, anything that's going to make this easier in terms of guidance and standardisation, I think will come down the line in good time.
Great. Thank you for that. Moving on to the next question. What are the accountability implications of the GDPR for senior staff under the senior managers regime? Craig, maybe you want to take that one again?
So the GDPR doesn't have any, like the senior manager regime, doesn't have any individual responsibilities for, say, board level individuals like the senior manager regime. But there has been some talk about potentially the UK moving to that model for GDPR in time. But at this point, there is no single accountability on a board member as there is in a senior manager regime.
Right, so no sort of responsibility on the DPO from an SMR perspective?
No. There is no single individual accountability under the GDPR or the SMR.
Okay. James, do you want to add anything to that from a legal perspective? Or?
No, I mean the big thing under GDPR is obviously the fines and the action that can be brought against an organisation directly. So I think that's the main focus at this moment in time.
Okay, great, thank you. Do we need to replace existing consent, James?
So yeah, interesting question, and we've been getting asked this quite a lot by clients. The GDPR is actually quite clear in its own recitals that you don't need to go and get new consents from data subjects, and it's a big but, the consent that you need to get, or if you want to carry on relying on your existing consents, those consents need to match up to what the GDPR expects. And the GDPR, as with lots of other things, has upped the ante a little bit on consent. And part of that is that when you get consent, it has to be an unambiguous indication of someone's wishes, and you evidence that through a statement or some affirmative action. So really what the GDPR is saying, you've got to be really clear in the consent statements that people sign up to what they're consenting to, what data you're going to use, what you're going to use it for, who you're giving the consent to, and then you need to have some sort of evidence that someone was okay with that. And it's got to be a positive indication from somebody that they're okay with that as well. And I think that creates a really big challenge for organisations relying on their existing consents, because we've not built them.
Yeah, but that's certainly from a customer perspective. But what about from an employee perspective?
Yeah, so employees are interesting as well. For a long time, the data protection regulators have sort of said, look, consent in the employee context is going to be difficult to gain. And one of the reasons they say that is because of the imbalance of power between an employee and an employer. So, their view is that an employee is likely to say yes to anything the employer asks. So, can your consent be valid if you're always going to give it in any respect? So, when you look at consent in the employment context, it's going to raise some real challenges, because the GDPR itself carries that theme that the regulators have started, where saying, where there's an imbalance of power, then it could invalidate consent in those situations. So consent in employment context is going to be very tricky.
Sure. Thank you for that, James. Just moving on. Another question we have come through. Historically, data protection regulation has focused on technology firms. So should FS firms be concerned about the GDPR? Taiba?
So I think that's right, but I think we are operating in a different world now, where most companies, including financial services companies, and maybe more so some of the newer challenger banks, are data companies at the heart of it, and they're collecting more and more data and various different types of data from multiple sources. So I think the ecosystem that we are currently in, even for financial services, is a very different one. And because of that, the rights of the customer, the rights of the employee on their own personal data needs to be protected. So the GDPR sort of broadens all of that and it applies equally to financial services firms, I think.
Sure. James, maybe you want to add a perspective to that?
Yeah, the GDPR was definitely drafted with large tech companies in mind, and particularly social media. Unfortunately, though, this law applies to all of us, and you could argue quite rightly so, because particularly when you look at financial services, those organisations hold vast amounts of personal data and also quite sensitive information about individuals. So, you know, there's no option for FS. We've got to get ready.
Yeah, great. Thank you for that. Just moving on, I think we've got time for one final question. What tools are there to support data mapping and management for the GDPR? Maybe Taiba?
So I think there are a number of technologies that are currently sort of focusing on the challenge of GDPR and its various requirements. Some of those technologies have been around for a while, so they've found a new use case in GDPR, and others are developing particular technologies to focus in on GDPR specifically. I think there isn't a one-stop shop. There isn't one solution out there that will help meet the breadth of GDPR requirements. So actually what we're looking at is more of a number of solutions that could be fit for purpose. And it's actually quite confusing because there's so many different vendors and so many different technologies. So one of the things that we're doing as an internal sort of exercise is to look at it from a reference architecture perspective, to look at the requirements that the GDPR is putting forward, such as transparency or right to be forgotten, which technically is a challenge for most financial services companies, and look at how various different technologies might be able to help solve that challenge.
Great. Craig, do you have a perspective or a view on that? Or?
No, I think overarching, you know, some of the tools around data management are now coming to the fore. I think there's that whole convergence over management of data and how organisations use not just, you know, go off and do this once and use kind of a one-hit approach, but how this is actually baked into the organisation. So some of those tools can enable those business as usual processes around oversight, around controls, effective controls over data and where processing happens, and can also then be used as that evidence base basis for compliance. So I think organisations should look at this holistically. Although this is GDPR, it is actually just really best practice over data processing and the protection of data, for which there are tools out there to help that.
Great, thank you, Craig. I guess it's clear from our discussion today that the GDPR should remain high on the agenda for all organisations. To wrap up, I would like to ask each of our panel for a final key message. Craig, would you? Yeah,
so for me, I think this is whether the programs need to be multidisciplinary. We know we've seen some organisations that just attack look at the cyber space and the cyber attack and the potential for that. But as you'll see in the GDPR, it spreads across many different themes and areas and functions that it will impact the business. And I think the acid test is if you've got a plan or a program in place, is to test how many functions are involved in that. How many? So just as an example, breach is not just about a cyber attack. A breach could happen as part of a mail shot that goes wrong.
Yeah.
And so how are organisations going to detect that? There needs to be awareness and education right across the organisation. So that would start to indicate that this is more than just legal or just compliance or just cyber. So the challenge here is multidisciplinary.
Thank you, Craig. Taiba?
So I think I would like to focus in on I guess the remaining time that organisations actually have to do quite a lot of work, and to really emphasise on prioritisation and really understand the outcome they're looking for from their GDPR programme. So I think the risk-based approach to all things in terms of both planning and execution is key, and to really be very strong on that.
Okay, great, thank you. And James?
Yeah, so GDPR sometimes feels like a little bit of a moving target. We're always waiting for new guidance from regulators. Somebody has a new opinion which they post online, and the debate continues. I think that when you boil it all down, GDPR is about having good data management in place and also respecting individuals, so respecting the rights of individuals. And I think that's important for organisations to focus on as some of their priority areas. The other part that I'd just add to this is that there's a lot of white space in between the text of the GDPR. And you can approach it in two ways. You can read that text and say, I'm going to take the most negative interpretation of the GDPR that is possible, the one that I think the regulators are expecting me to take. Or you can say, there's no guidance yet on this subject. It is open for us to influence and interpret that part of the implementation of the provisions in the GDPR such that we do it in a positive way, one that is beneficial to us as an organisation, rather than instantly going to the more negative interpretation of the GDPR.
Great. Well, thank you, Craig, Taiba and James. The GDPR will be a significant change to the way organisations will operate from May 2018, with data ownership shifting to customers. It is also an opportunity to embrace other regulations such as PSD2. If you found today useful, this webcast will be available online for your colleagues to also see shortly. This and all of our GDPR-related materials can be found at pwc.co.uk/GDPR. So I'd just like to say thank you for watching. It's been a great debate, and thank you for all the questions from the audience. Thank you.